In every Second Amendment lawsuit, there's two things you need to know about. One is the procedure or the process by which a case gets handled. The other, of course, is the substance of the Second Amendment's right to keep and bear arms. Today, I want to talk about the procedure because so many of you have asked me the question, what can we do about these politicians that repeatedly violate the Second Amendment and nothing happens to them? Well, let's talk about this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the four boxes of American liberty. Okay, folks, I want to talk about a question that's presented all the time to me. What can be done with all these politicians who are voting against our Second Amendment rights, and none of them have to pay damages, and none of them seem to be punished? And why can't we sue them for money and take money from their pockets? All right, so I'm going to answer this question, but I want to start with the concept of a lawsuit, meaning, remember, this is very important to understand. At the start of a lawsuit, including a Second Amendment lawsuit, meaning a challenge to a modern-day gun control law, the way to understand lawsuits in all respects, by the way, is you have two parties. One party or person wants the status quo to continue. They like the way the world is today, and they do not want to change it. So usually, in the context of a Second Amendment fight, that is a politician or a government official that has enacted a gun control law that they want to enforce against American gun owners. So they like the status quo because there's a gun law that they enacted or what have you, and they want to enforce it. So they want the status quo to continue. They do not want it to change. In contrast, the plaintiffs or the gun owners or the Second Amendment organizations who sue in court to challenge the gun control law are basically asking a court to change or alter the status quo. In other words, there is a gun control law in the books. The state defendant, like the state of California defendant, likes the law and doesn't want it changed. The plaintiffs, in support of the Second Amendment, sue trying to change the status quo by usually trying to enjoin or to stop the enforcement of that modern-day gun control law. So always remember when you look at any lawsuit or legal case, one party likes the status quo, one party wants to change the status quo. Quickly, in the context of criminal cases, of course, the criminal defendant likes the status quo because he is presumed innocent, he is presumed not guilty, and he likes to not be in prison, whereas the district attorney or the government that seeks to change the status quo in a criminal case by making you go from being an innocent, presumed innocent person to a convicted criminal that they can then put in jail or whatever they want to do with you. So you see in the context of a criminal case, the government wants to change the status quo, but the private citizen wants the status quo to continue. Always keep this in mind, this dynamic at all times when you're analyzing any kind of lawsuit. Some people like the status quo, the other people want to change it. Always keep this in mind. Now, in the context of Second Amendment litigations, there's two areas of law that we should always keep in mind. One is the procedural. Procedural is the process by which a case proceeds forward, meaning there is a complaint filed to start the lawsuit that lays out the complaints. There is an answer filed or a motion to dismiss filed by the government, and so on and so on. These are procedurals, a process, and then, of course, someone wins or loses the case in the trial court. It then gets appealed to an appellate court, then potentially gets appealed all the way to the U.S. Supreme Court. The process whereby this occurs is called procedural, and that's important to understand for 1 second. I'll tell you about it in 1 second. And that's in contrast, of course, to the substance of a case, which could be a particular type of substantive law. In our context of the Second Amendment, it's the right to keep and bear arms. What does the right to keep and bear arms mean by virtue of the Supreme Court precedents? What is allowed? What analogies do you consider? All that is substantive law to be distinguished from procedural law. Today I want to talk about procedure or the process a little bit because a lot of you keep asking me, why is it that these politicians don't get punished and why don't they have to pay damages? So I'm going to break it down really quickly for you and keep it nice and simple. Number one, when a person is a legislator and they vote for gun control law, as a general matter, you cannot sue them for their act of voting. They have a form of immunity, so you can't sue them solely for voting their mind, even when they're clearly doing something that in our view would be deemed unconstitutional. So your remedy in that case is not to sue that person for damages or anything like that. It's that you sue the government to enjoin or stop the enforcement of the law they just passed. Now, sometimes you may say, why can't a federal court enter damages against the people responsible for enforcing the gun control law? Why can't we sue for damages against the ATF? Why can't we sue for damages against a bureaucrat? Why can't we sue Gavin Newsom, the governor of California, for damages? Well, the answer is the 11th Amendment of the United States Constitution. The 11th Amendment of the U.S. Constitution precludes this. It specifically says that federal courts cannot award any kind of damages against state actors who are allegedly violate the Constitution. Now, there's extremely narrow exception to this, dealing with the Fourth Amendment's unreasonable search and seizures as applied to law enforcement officers like police officers. It's extremely narrow and rarely used, but technically speaking, there is a way to sue police officers under the Fourth Amendment, but when it comes to Second Amendment violations, there's no way to sue police officers or anyone for money damages because of, among other things, the 11th Amendment. And moreover, there's also certain qualified immunities associated with it beyond that. So as a practical matter, damages are out the window, which means the only thing we can do is seek injunctive relief. Sometimes this is called a form of equity, but bottom line is we sue to try to enjoin the law from being enforced, and that is what we really can do. Now, there is a way, so the question is, how do these government officials get punished? Well, unfortunately, there's not a great way to punish them personally financially because the law doesn't really contemplate that or allow for that, which is kind of unfortunate. And again, the 11th Amendment and beyond. But with that said, there is a way to make some money off these cases in a way, because under a federal statute, 42 U.S.C. 1988, is an attorney fee provision for what are known as private attorney generals. We all know what the attorney general of the state is. That's the lead law enforcement officer for the state of New York or California. And we know the federal attorney general in today is Merrick Garland under Joe Biden. The reason why I mention this is you have a notion of private attorney general, because the concept of an attorney general is they're supposed to advance the public interest. You and I can, of course, disagree on that. I'm not sure Merrick Garland's advancing the public interest as I see it. Nevertheless, that is supposed to be their job as they see it. With that said, private attorney generals are people who sue to vindicate, for example, constitutional rights that are being violated, or sue to vindicate civil rights that are being violated by somebody. These lawyers are sometimes referred to as private attorney generals, seeking to advance the public good to vindicate certain rights, even though they don't officially work for the government. Now, as to reward them or to encourage this kind of private attorney general behavior, Congress passed a law which provides for attorney's fees to the attorney that represented the prevailing party in a civil rights case or constitutional case. So, for example, if you sued the state of New York over a Second Amendment violation and you ultimately win that case, your attorneys may apply to the court for their reasonable award of attorney's fees, and they would use 42 U.S.C. 1988 to recover those. So again, under 42 U.S.C. 1988, that's Title 42 U.S.C. 1988, attorney's fees are available to attorneys that represent someone that is a prevailing party in a Second Amendment case. So at least there is some payment made by government agents who ultimately lose a Second Amendment case. Unfortunately, that's usually paid for by the taxpayer. Now, in terms of how you hold a legislative body accountable, well, go back to the 4 Boxes of American Liberty. Remember, the 4 Boxes Diner channel that you're watching right now is named after the 4 Boxes of American Liberty. We know what those boxes are. They are, of course, the cartridge box, which is, firearms, the right to bear arms. There are the ballot box, which is, of course, voting. There is, of course, the jury box, which is the rule of law. And last but not least, there's the soap box, which is the right to free speech under the First Amendment. So the concept that the Founding Fathers had is one of the many checks on to protect our freedom. One of those checks, not the only one, but one of them was the ability to vote the bums out. So if someone keeps violating the Constitution, in theory, you can vote them out. Now, I know that's kind of a stretch to think that AOC is going to be voted out for violating our Second Amendment rights in, New York City. but nevertheless, that is at least conceptually a possibility, and that is what the Founding Fathers thought of a single, again, not the only check, but one of the checks there to check bad behavior by legislators for their bad votes. So the last thing I want to mention is class actions, because sometimes people have asked me about class actions. Okay, let me be crystal clear. Class actions are completely unnecessary in the context of Second Amendment litigations. Because if you think about it, and I'm going to define class actions in a second, but if you think about it, if I personally sue, let's say, the state of New York to enjoin a gun control law, and I win, and the U.S. Supreme Court declares that New York state law involving firearms to be unconstitutional under the Second Amendment, I'm the winning plaintiff. You are not a winning plaintiff, are you? Nevertheless, because it basically is an injunction of the entire law for the state, you, just by virtue of sitting at home, will benefit from my court victory, even if you do nothing but nothing at all and just sit on your couch, because the law will be enjoined not just for me, but generally speaking for the whole state. And even if it's not applicable initially to you, nothing would prevent you and others from immediately suing using my case as precedent for you to go ahead and win. So quickly, of course, the state will just stop enforcing it and it's game over. You do not need a class action to accomplish this. Now, the main reason why, in addition to the fact that a class action is unnecessary, it's also unduly cumbersome and expensive. I'm going to spend 1 minute on this. To have a class action, usually it revolves around a single event. There is a bus crash. There is a plane crash. There is a particular event that impacts a whole bunch of people, like all the passengers on that plane. So if a plane crashes because a mechanic engaged in negligence and did not properly, handle the ailerons right or the flaps right or something, and the plane crashes, the 100 people on that plane will all be litigating the exact same issue, whether or not there was negligence by the mechanic in the way the plane flew, and that got them all killed, and their families sue. That would be an example where a class action would make sense, where everyone basically gets together as a class that are equally affected and then litigate against the mechanic. But that's involving the application of different things, such as how you whack up the money and everything else. Beyond that, you need 4 things you have to prove for class certification before you even get to the merits of the case. You have to show that it's a situation where you need numerosity, where there's a sufficient number of plaintiffs that are impacted by a particular event. Number 2 is you got to show that the class representatives that speak for the whole class, because usually you may have a 100-person class, but only 1 or 2 people represent the class. You got to make sure that those representatives are typical and adequate. Likewise, you have to do a litigation as to whether or not the lawyers representing the class are adequate and competent. That takes time to establish that. And of course, you got typicality, numerosity, all these other things. Bottom line is there's a whole process to figure out whether or not a class should be certified in the first instance before you ever even start talking about the substance of a case, such as whether or not a law violates the Second Amendment. That's why, in my view, class actions are totally unnecessary. If anything, they're not only are they unnecessary in the Second Amendment context, but they actually slow you down because you spend so much time litigating whether or not a class should be certified into a class action before you get to the merits of the case, i.e. the Second Amendment. That is a bunch of time that's wasted delaying the process. And again, if you're a plaintiff suing over a gun control law to try to knock it out, you want to change the status quo as fast as possible. And if you have to litigate class certification, meaning whether or not there's a class, is it adequately represented by counsel, is it adequately represented by the plaintiff's representatives, and so on, this is a bunch of procedural hooey, at least in the context of the Second Amendment, that is really unnecessary to be done and only delays the litigation of the merits, as opposed to simply suing on behalf of a handful of people seeking injunctive relief immediately. That is, to me, a much more efficient way, and the class action approach is simply unnecessary, cumbersome, and just sucks up a bunch of time for no great advantage to anyone. At least that's how I see it. Okay, folks, I hope this wasn't too geeky. I know we talked about procedural, some of this stuff, answering some of your questions. Hope you learned a little bit something here today. And if you haven't subscribed to the 4 Boxes Diner, please do so. But we'll see you again here soon at the 4 Boxes Diner.
Orders up. Table 2A.